is where things like half measures, like joint tenancies, things like transfer on death, pay on death, deeds or account designations may or may not be so effective for you, because if everything, my home is a transfer on death deed, my bank account is a transfer on death account, my retirement plan is beneficiary, when I pass away, what happens if I have dementia? What happens if I don't have mental capacity? None of that is triggered. It's all still with Mike, and it doesn't go over to the beneficiary, and it shouldn't go to the beneficiary. It actually should be used for my care. How do we do that? So that's a big part of the estate plan design. Also, for married couples, how to manage assets for a period of time when one spouse passes before the next spouse passes. This is always a hard thing to think about, but it is a reality of a couple, is that couples will not pass at the same time. There will be a gap period. And this gap period can be an area for disharmony and inefficiency, because there can be concerns over, if I go, what happens to my half of the assets? Does my spouse have total control over this? Can she marry again and expose these assets to someone else? This is something very critical to think about in your estate planning. And I see a lot of errors in this for estate planning is definition of adoption. I see a lot of plans where they say, if the child is legally adopted, and people say, oh, yeah, if I marry again and the person has small children, I just won't legally adopt. I won't file a petition to adopt them. I didn't legally adopt them. So better be careful in California, because we have statutory adoption, we have equitable adoption. So these children can claim potentially, even though you said, well, I never filed a petition in my lifetime, I didn't actually adopt these kids. Statutory adoption is you sort of lived as parents to the child, and you would have adopted them, but for some legal barrier. It's usually that their other parent won't agree to the adoption. That's about 95% of the time. So very risky. That can expose additional persons into the estate plan. There's a lot of things going on there. So this planning for the gap period. That's also true for beneficiaries, is how do you define your heirs in the future? Your children doesn't include beneficiaries who adopt or potentially have an issue of statutory or equitable adoption. The other thing, going on to our point 4 here, allocation and transfer, hold assets. The estate has to hold assets and then allocate those eventually to beneficiaries. This is prime for conflict, and a lot of people, the instinct, oh, well, I'll give it half and half. Give it half, half to daughter, half to son, or I'll give it a third, a third, a third. It's fair. It's a third, a third, a third. You have to think this through a little bit more. And the job of the lawyer is sometimes to get the wheels turning and to start thinking these things through. My job as the lawyer, and the same as financial professionals, is to tell you something you don't know. A lot of clients come in and they say, oh, Michael, I'm going to tell you how, what I want for the estate plan. It's really simple. I'm a really good client. I'll be very, I'll save you a lot of time. I'm just going to tell you, I want, kids as trustee, I want a third, a third, a third. Really easy. Just do that for me. I saved you a lot of time and we just do that. Great. I say, actually, I want to spend a little more time with you. My job is to tell you something you don't know. And one of the things that sometimes people don't know, but is obvious, is not everything splits well in thirds. If your estate is all cash, probably splits well in thirds. I have few clients that things split well in thirds. We'll see this in a moment of designing. Sometimes we have to be a little bit more clever. And the last thing for goals, we want to accomplish all of the above with low costs and tax efficiency. So what I like to go into is I have a couple of slides of things of what not to do. And I've been practicing almost 15 years. We've seen a lot of things where I look at it and I'm like, oh man, why did they do this? How did they get themselves into this fix? And sometimes I think, oh, well, this was one that was kind of a bonehead thing that they got themselves into. And then other times I think I'll see something I thought, and this is the one that really opens my eyes. I think, oh no, I'm doing that. I did something like that. That's not necessarily, an unintelligent thing to do. It's just there's more to it than it appears. So here's some of my top list of things that there's more to it than it appears. We have to think it through. First one is a classic one. My father's family, Chinese, Cantonese from Guangzhou, actually Zhongshan, but they're from the south. This is very common planning among that community in Los Angeles, especially Los Angeles, very, very common, but very common in the Bay Area too, is using things like joint tenancies, transfer on death, pay on death. Interesting thing, especially the joint tenancies for real estate. This was never intended as an estate planning device. It was an old remnant of the common law of England 500 years ago to maintain the large estates, to ensure that the land was never broken into smaller pieces. It still exists because it's been around for 1,000 years, literally 1,000 years, since 1065. But the problem with this is it is unpredictable. And so I always recommend with clients to say, I don't need to do the trust planning. I did the joint tenancies, the pay on deaths, the transfer on deaths, it's fine. When is this okay? Maybe a very small estate, it's fine. It's not worth it to go into all of the estate planning because it's just a small house out in, far Eastern California, and we're just trying to do something simple, and we don't need something so complicated. But really, for anyone else, this can go wrong pretty quickly. One of the problems with the joint tenancies is, of course, if I hold with, let's say, my son, if he gets in trouble, he hits somebody with the car and he gets sued, that half is his half. They're going to take half that house. He's a present owner. So everybody who's on the title presently, they expose the property to risk. That's really bad asset protection planning, by the way. You don't want to do that. Also, it assumes situations of people passing in order. So if people pass out of order, if my son is an adult and he has a family and we're on his joint tenants, probably I want his half to go to his family or benefit his family. If I'm on with him as joint tenants, it goes to me. This can be problematic for a number of tax reasons that it got complicated. We look at separately. So joint tenancies, transfer on death, terrible for incapacity planning, not good for asset protection planning because exposed to liability, and can behave unpredictably. So we have to be a little bit cautious with these. And sometimes they're all right, but we definitely want to only deploy them when it makes good sense. The other thing, I see this problem all the time, and this one is a heartbreaker, is failure to coordinate non-probate assets that don't have anything to do with probate, don't have anything to do with the living trust. They pass by operation of law, by operation of the system that they're in. What's an asset like this? Retirement plans, IRA, 401k, 503b, union pension plan, all of these things. These do not go through probate. They generally do not go through the revocable living trust. You generally name beneficiaries. One of the things to think about is people often do make a mistake in two ways. Generally, under the new law, it's called the Secure Act, you generally want to name your spouse as the beneficiary. If you name anyone other than the spouse, their particular share must be drawn down. It must pour out of the plan within 10 years of the person passing away. That is really unfortunate when you see situations where they do something like, and I've seen clients do this, is where you have the pension plan split between, wife gets half and child gets half. Well, if it went to wife, she can continue the plan and the benefit of the tax-free retirement growth up until she hits the RMD years, 72 and a half, hits upper age limit. But that portion with regard to the children has to begin pouring out 10 years. It must pour all out within the 10 years. So it starts front loading income tax to that beneficiary. So that's not good. It's doubly not good if that beneficiary is a minor, because now you have this minor who is receiving retirement plan payments, but the minor is a minor, can't appropriately deal with this, It's going to trigger a court guardianship of the estate. You're going to incur all kinds of costs for that. And then the child technically owes taxes. It's probably going to be picked up by the kiddie tax and thrown back onto the other parent. It's going to become really a big problem. So coordinating the non-probate assets, if the beneficiary, if there's a spouse, probably spouse first, and then contingent beneficiary, if they're adult children, the children, if they're minors, then maybe the revocable living trust. But coordinating this is a kind of a classic mistake. The other one that I see all the time, this I see constantly, and we have to go to court for this constantly, is failure to fund the estate plan. This happens a lot with the do-it-yourself trust. In fact, happens probably, I'd say probably the most common is the do-it-yourself trust, the internet trust. Second one is lawyers who do quickie estate planning. That's probably the second one. Or the third one is, well, my friend is a lawyer, divorce lawyer, or more commonly an immigration lawyer. And he or she threw it together. They said they don't really do it, but, you know, a friend, they put it together. And I've got a trust. You have to actually fund the trust. You have to actually get the assets into the box of the trust. You have to prepare real estate deeds. You have to record these. You have to look at your assets. Certain assets need to be put into the trust while you're living. I always give the warning, don't be John Paul Getty. If you're familiar, who is John Paul Getty? He was the owner of Standard Oil. The estate was something like $1.3 billion in the 1980s. He died intestate. It's no will, no trust. And the attorney's fees were $13 million in 1983. So $13 million, I'd take $13 million today. But in 1983, it was $13 million. $38 million in probate attorney's fees, because probate attorney's fees are calculated on the value of the gross assets of the estate. So we do a percentage. We get a percentage of what passes through an estate. So don't fail to fund your estate plan. Don't pass intestate. Don't be John Paul Getty. If you read up on John Paul Getty, there's a whole host of reasons why you don't want to be this guy. He was kind of a slimy guy, but for donating a lot of money for beautiful art, you don't really want to follow this guy in terms of a lot of your harmony planning and estate planning. So learn from other people's mistakes. Don't do that. The other things that I see, major problems. Failure to update your estate plan. This is another problem that occurs very much. People say, I got an estate plan. See this frequently. Sometimes they're actually very interesting in that see some plans from the early 2000s, the 1990s. The more interesting ones are the early 1990s and the late 1980s ones, because of the designs that they had back then, because of the estate tax. The problem with these is that particularly the ones from the late 90s and the early 2000s is the estate tax law operated in a total or conceptually different way than it operates now. The concept of how the exemptions worked, how you got money to the next generation tax-free, conceptually worked differently. And that poses major problems for administering an estate today. So if you have a plan older than 2013 and definitely older than 2010, we should talk about that, because your plan, odds are, will not operate tax-wise the way that you want. One is it will lock up half the assets in the A-B trust, in the B trust. That will cause a very cumbersome administration of the B trust. You have to file a special tax return every year for this, 1041 and 541 California. And you lose the double step up in basis. You don't get a step up in basis on that other half. So you get it the first time when the person died, but you don't get the second one. So California, community property states give you two opportunities to wash out capital gains. You're missing one if you have an old plan. So that basically front loads a lot of administrative costs, which gets you nothing, and causes you to lose the benefit of the step up in basis. The other thing that we see with failure to update the plan is plans that just don't work in terms of family harmony. The trustees are not right. You have a a distant, sibling, brother or sister was closer. Now they live in a different place, or they're just not as familiar with the family as it used to be. The trusteeship, the leader of the trust, the administrator of the trust, is not the right person. Big problem. Beneficiary, are the beneficiaries right? Usually, if one's choosing children, usually the children are the same. They remain beneficiaries, but not always. And you don't always want to give, and this is another thing we'll talk about in a moment, give beneficiaries outright distributions. Outright distributions is basically mailing the kid a check in the future that's basically made out to cash. Basically says, dear son, in 2059, here's your money made out to cash, and I'm mailing it today. That's a disaster. Why? Because I don't know what's happening with my son in 2059. I don't know if he's going through an ugly divorce. I don't know if I think, if you saw SBF, Sam Bankman-Fried's parents, about 2 months ago, they were real proud of that guy. Now that guy's going to jail forever. Probably don't want a trust that has an outright distribution to him. You have to kind of dial this in. We'll talk about a technique called withdrawal rights in a little bit. So failure to update the plan to the situation that you're dealing with can be a big problem. The last one also is bad plan design, non-tax. And this is kind of like what we're talking about. Does the plan promote harmony or conflict? And in interest of time, I didn't offer the video clip, but if you are of a certain generation, there was a television show called Dallas in the United States. And basically, there's a family that owned a very big oil company, kind of like the John Paul Getty story. And the television series, which was on for many years, one of the big sort of season finales was the father dies and he has a will. And it's regarding, of course, the ownership of the company. And the provision of the will is that for 1 year, the company is split in half. Son 1 gets half and son 2 gets half. They operate the company for 1 year. And at the end, we determine who made more money, and he who made more money gets the company. And the other brother gets a smaller amount and is not in charge of the company. Does that design promote harmony or conflict? That promotes conflict. While, of course, I don't have clients as extreme as that, you can often see in plans where the plan may put beneficiaries on a collision course. It may put people at odds with each other regarding decision-making, things like this. Classic one are, again, like we were talking about before, it seems inherently fair, a third, a third, a third. The problem is some things are non-fungible. They don't divide well. And classic among these is real estate does not divide well. And that's something that a plan really needs to think about, because if I say a third, a third, a third, and I have 2 houses, we're going to have to kind of think about this, because one of them, or maybe both of them, are going to need to be sold. And maybe we want to do that, maybe we don't. There's all kinds of concerns about this. And that's a classic one. This is a kind of classic beginning of the story of 2 houses, a third, a third, a third. One of the children lives in the houses, is keeping under Prop 19 the good tax basis. So that's good. One of them got reassessed. Maybe we can agree to sell that one. But then there's this problem of the child living in that one house. And how do we do this? Because, depending on the values, maybe the first one is worth more. We have to think about that. Is it causing conflict or is it not? And this is the thing, again, working with the lawyer and, talking about, let me tell you something I don't know. Let me play devil's advocate a little bit with your planning. The best advice I got is a young lawyer was from a judge that said, your job is to be a lawyer, not a butler. And my job is actually to test a little bit some of your ideas and make sure that they're good. Because if I just say, yes, 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 I'll write down whatever you want, why hire me? Why bother. Just write down what you want. The thing is that you don't come to me to write things down. I think you probably already know how to write. You hire me because we want to actually go through a process and have me tell you something that you don't already know. So continuing on are what not to do. Some bad designs are non-tax. Some bad designs are tax. Of the number of things that are bad tax designs, classic one is we have to think about the primary residence issue in light of Prop 19. So one of the classic concerns of California estate planning is the primary residence from the fair market, from basically the tax assessment where it is now, the adjusted base value now, plus $1 million. If that is lower than the fair market value at the time it transfers to the next generation, it will keep the original tax basis. If it is higher, it gets adjusted for the amount higher, but you still get the $3 million in the middle. Critically, in order to get this, the child has to live in the house. So this is something to think about with, again, the tax design and the general forward thinking of the estate plan. Is anyone going to live in mom and dad's house? Who? If someone's living in mom and dad's house, we're going to, brother or sister, we got to think about, wait, if brother's in the house and he's enjoying all the house, how is sister made whole? How do we buy her out? Because of course, brother will say, I'll just add you on the title. No problem. We'll just add you on the title. The trust will just put you out on title. Okay. But then sister says, yeah, but I just having the title to a house that I don't live in and can't live in, that you live in with your family, doesn't really help me. That's going to be a problem. And if we do it in two steps, a step transaction where it comes out brother and sister, we initially qualified it in Prop 19, but then brother does a loan and buys out sister, it's going to get reassessed. It's going to defeat the whole thing. We have to do this up at the trust level. So this is something we got to figure out. We already talked about before, but beneficiaries and retirement plans, think that through because of the Secure Act. We have to be careful how we name retirement plan beneficiaries. Spouse is a double step up in basis. Don't lose the double step up in basis. If you are a large estate, you really have to do planning because of the estate tax. This AB trust system may be better for you, partly because of the ABC trust. It's the C part. The bypass is what you're really looking for. That can be helpful for estate taxes for growing assets. This next one, this is second to the last one. The last two I kind of say for most important. If you are a multinational couple, citizen and permanent resident, both permanent residents, citizen and non-resident alien, permanent resident and non-citizen, non-resident, you got to come see me. We really got to take care of this because the estate tax and the marital exclusion works differently for you guys. You are not treated identically as U.S. citizens. Depending on how your trust is designed, it may do the wrong thing. It may cause kind of a mess. So that is something that is very important to make sure that this is tuned for a multinational couple. And it's very important to know this because the generic template, I'll tell you, the lawyers, there are basic core trust backbones that good lawyers use. And there are about 3 to 4, maybe 5 quality trust backbones. There's Wealth Counsel, there's Hertog, there's a few others that are quality backbones. The general backbone, all of them, are designed for citizen and citizen because that's the majority of American, for lawyers who write for other lawyers, that is the most common client profile. But for our community, it is not. For our Bay Area community, it's not uncommon that one or both spouses are either are multinational. So, pardon me, for this situation, you really have to look at what is going on and use an attorney and expert who knows how to do the multinational planning, because that's really critical. The other thing that is very, very important to do, and I see this is an error for most mid-sized estates, very important for a mid-sized estate. A small estate, maybe not necessary, but for mid-sized estate is very necessary, is the failure to file the estate tax return, especially on the passing of the first spouse. And a lot of people say, I don't need to file that thing. I don't need to file that thing. Well, maybe you truly don't if your assets are small enough. But think of it this way. The IRS gives everybody a tax-free ticket for the estate tax. And each person gets, right now, a $12 million ticket and a $12 million ticket for estate tax. And a lot of people say, well, our estate's way, way lower than that. I don't need to do it. But let's think it through. The IRS gave you this free ticket. If one spouse passes away, in order to give it to the other spouse, all you have to do is file the estate tax return. It's not terribly complicated. It's not terribly simple, but it's not terribly complicated. It's not a tremendous process. But that will transfer the value of this ticket to the other spouse. So surviving spouse, instead of having her amount of loan, let's say 12 million, it will be 24 million. When she goes, she'll have 24 million if all the assets go to her. So basically, the IRS is giving you an estate value that they'll say is tax-free, but you have to ask for it on the filed estate tax form. So for estates that are, I'd say, less than $6 million, you don't really need to do this. It's not so critical. But for estates that are $6 million and close, I'd say even $4 million, do remember that after 2025, the individual estate tax exemption is only 6 million. So if you're for 6 million and then husband passes away and you don't file the estate tax return, you threw away the ticket. You threw away the free 6 million ticket for husband. And then wife, she continues living. The assets were 6 million. They go a little bit above 6 million. She passes. She goes to turn in the ticket. They say, oh, thank you for your ticket. Sorry, madam, you're short. You owe. I say, but what about my husband? They say, yeah, he threw it away. You didn't file the return. You didn't ask to take the ticket. So you only have yours and you're short. And you're short on whatever is over the $6 million, it's taxed at a 40% rate. So don't fail to file the estate tax return. If something has happened, somebody who's done this, the return can be filed late. There are procedures that even up to 5 years after the person passed away, you can file the return and go get the ticket and say, oh, no. Just like once I was in Japan traveling and I actually I lost a Japanese train ticket. The estate tax exemption is very much like a Japanese train ticket. There is no record of the ticket aside from the paper ticket. And that's just like the estate tax exemption. You have to actually have the physical ticket in the sense that you actually have to, if something happens, file the return and say, I want the ticket, give it to the other person. So if you know anyone or you are in this situation, certainly consider the estate tax return, because in that same situation, if the husband passed away and she had the estate of 6 million, if she filed the estate tax return, guess how much she would have? A lot of people would guess 12. If he passed between now and 2025, he has 12, she has 6, 18. They have $18 million estate tax exempt. So she'd totally be clear. When she turns in her ticket, they say, oh, madam, you're far over. Children, enjoy the assets of the estate, no tax. Have 18 million exemption. You're totally clear. But if they didn't do that, they're going to say, sorry, you're short. So we don't want that to happen. So how do you avoid problems with this? How do you do it right? Get help. Use professionals wisely. I had as people my age had required some significant dental work. I'll tell you, one of the first things that did not go through my mind was that I want to do this myself. I don't really want to do wisdom tooth surgery on my own in the mirror in my bathroom. I want to get a surgeon. and a dentist, both actually. So a dentist first, oral surgeon second, because I know things that I don't know. And how to do oral surgery is one of the things I don't know how to do. So I get people who know how to do it and do it for me. That's the same thing. We all make money in different ways. My plan, I do estate planning. I know this, so you don't have to. Same way you do things that I don't know, and we exchange. And so use professionals wisely. And what to do. Here's some things of what to do. Build your team of professionals, your attorney, your financial advisor, accountant. You got to get your team together, because again, why take on all this burden? This area, this estate tax planning has been an entire career for one person. Same as financial advisor. We'll see a lot of your advisors, nine fortunes. It's their entire career. They say, I've spent my lifetime learning these things. Don't try to learn it in an afternoon. Learn to say, I understand what the problem is. I need help. Then go find somebody who made it their career to know how to guide you. Go do that. And then once you do that, you get your team together, you build your plan, you establish the plan, estate plan, legal estate plan, establish the financial plan. You got to make sure there's actually money in this thing, that this is actually funded, and not funded by deeding it. You actually have to make sure that you're financially planned well, and then establish how it's actually going to be deployed. Again, think about how you're actually going to do this thing in real life. Classically, again, estate plan, revocable living trust, it's funded, deeds, titles, all that, pour over wills, durable powers of attorney, advanced healthcare directives, all that. Trust designs that work. Here are things that are good ideas. First one, it's often called the Q-tip. And basically what this is how do I, for my half of the estate, if I go, make sure that basically my wife can have the income from my side that's not really troublesome, but I'd really prefer that if I go and she runs off with the pool boy, that she doesn't just give him all of the assets because she's swooning with finally getting somebody handsome. How do I prevent that from happening? Use this thing called the Q-tip. Basically have the attorney design where if I go, my half lightly locks. And a very common provision is say, if I go, my half lightly locks, and for this locked half, my wife can get income, she can use all of the property, but she can't suddenly take the principal out and give it away. Unless if she really wants to get into the principal, she needs the consent of the children, I'm presuming they're adults by that time. So in that design, it's flexible enough. If the kids are convinced, if the kids really love the pool boy, the same as my wife, fine. That's probably the best I can do. I can remove that. I don't have to have that. I could say that it's fixed and locked. But a lot of people say, if, well, everybody's consenting, then fine. We can design something so that we can take care of that gap period that I mentioned at the beginning. Spouses generally are not going to pass at the same time. There's going to be a period of time. One of them is alone. How do I prevent that person from making bad decisions with my half? We can lock that up. It's classic. We can lock that up. Next thing, withdrawal rights. Like I mentioned before, I don't want to send my kid a blank check 50, 60, 70 years in the future. Instead, what we give them are withdrawal rights. I will give them tiered withdrawal rights at ages. So like for minor children, if my wife and I go suddenly, they don't all get it at 18. Maybe they don't get anything until they're 25 and it's only 15%. And then at 30, they get another percent. And then at 40, they get the final percentage. We can dial it in. We can make it more restrictive. We can make it less restrictive. We can look at the particular children's profiles and create something that's either a withdrawal right or a managed trust to make sure that we're not sending a blank check 30 years in the future. Neutral trustees. Do we really want a family member to be the trustee? This is a big one. It always is, again, instinctive that people say, well, the three kids will be the three beneficiaries, a third, a third, a third, and they all three will be the trustee, all with unanimous. They all have to have unanimous consent. Log jamming problem. Things don't divide. All three are beneficiaries. All three have to sign. Impasse. is it just doesn't work. So you don't have no one is actually in control. Everybody has a vote. Everybody is self-interested. Everybody is tearing the thing apart. You did not actually make it super fair with this third, vote, vote, vote. You actually caused the collision. So think about, are there times when maybe we say we need a neutral trustee? Or what about a trust protector? What if we say, do we need a super trustee? Someone to watch over the whole thing. We'll say, all right, actually, Mike, I don't think the brothers get along pretty well. There's 3 houses. In fact, we did specific distributions, 1, 2, 3. They're not going to fight because of that, because it's fixed. But who knows? Maybe we need a trust protector, some super trustee in a sense, to basically, if things really hit the fan, to change the trusteeship, to take over the trusteeship, to settle disputes, to be a tiebreaker. Maybe we need somebody like that. We got an office for that. We got a solution for that called the trust protector. And it can be a professional. It can be another family member. There can be a lot of different things. So we have techniques for that. Last one, sometimes specific gifts. This one is, I almost put this in the things not to do. And it goes both ways, of things to do and things not to do. Real case, I saw in an estate plan that the particular beneficiary, we'll just call her Cindy, shall get the bronze cat with patina statue. And the bronze cat with patina statue was worth nothing. It got appraised and was literally found to be worth nothing. Partly because apparently they cranked these things out in the 1950s or 1960s. So if you basically go to any yard sale, you can basically find this thing. But that particular one, the beneficiary wanted very much. And the estate was very clear that Cindy shall get the bronze cat with the patina on it, which was basically, patina is kind of a fancy word for rust. It's that blue stuff that makes it look old, but lay people will call it rusted cat that's old. Specific gifts, how can they be good? It's clear. This goes to you, that goes to you, that goes to you. Done. No dividing, no allocating. It's just you, you, you. This can solve disputes. This can sometimes cause disputes. So again, this is one kind of talking it out and working with the lawyer and thinking it through. Is this going to solve the bronze cat problem, or is this going to create a bronze cat problem? So that's what we'd want to take a look at, is that one can really go both ways. I've seen that cause trouble and that solve troubles. So again, it varies. We have to fit it to you. So some tax strategies that work, things that we want to do. That first one we already talked about, file the estate tax plan. Don't throw away the ticket. Don't put the ticket in the old coat and then throw the coat away or give it away. They're giving you the free estate tax exemption. If you're in a state that may need it, you think maybe I might need it, file it. Just file it. Go get your ticket. The other thing to do is think about this, the other critical thing, which is very common in California, Prop 19. Think about that primary residence and who will actually live there. Because if, as we're growing up and the family's growing up, and we realize that no one is going to actually live there, as we say, oh, actually, my son, is living in New York and actually bought a house in New York. We helped him buy the house in New York. And my daughter, she's down in Florida. She does her, she is a thing for, sea turtles or something in Florida. She'll never be able to leave Florida because she's got to be near the coast for the sea turtles. That's another real client. I actually encountered this. A client, the kid can never move away because the job is deeply entrenched with where the location of whatever the work is. We got a problem because that primary residence is going to be reassessed. So maybe we're going to have to, hard to think about, but maybe that we're going to have to realize that's going to sell. And that's some of the planning or thinking things through with this estate planning is oftentimes parents say, we'd love to keep the house in the family, but some, times we have to be realistic. So thinking that through, because if we don't think it through, and then it causes a period of time, a long period of time with long periods of holding, and it's reassessed, you're going to be in buku trouble. This is very true of houses in Palo Alto, Los Altos, Hillsborough. Parents said, "Oh, I bought the thing for $400,000 in the '60s." I said, "How much is it worth now? 4 million." Oh, that gets reassessed, and man, you're looking at a very you're looking at $100,000, hundreds of thousands of dollars property tax bill. You've got a big problem, and so understanding what's going to happen there, you need to know. Other thing, if you have rental properties, do know under Prop 19, your rentals are all going to get reassessed. Every single one of them in California. Out of state, no. Going to depend on the state law of where they are. If you got California rentals, all going to get reassessed. Boom, 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 reassessed as soon as you go. And you say, well, a lot of people say, well, I'll kind of wait, before I transfer the property. The county assessor's not going to know. They'll know. They figure it out pretty well because death certificates are filed with the county, so they know. The other thing is that even if they don't know, when they eventually figure it out, they just charge it backwards. And you get the escape assessment. They said you escaped from the assessment. And very hard to escape with real estate. Very bad asset if you're a guy on the run is to try to take real estate with you. Real estate, hard to take with you. So they got you. So this is one, it's kind of a trick. If you have commercial real property, think about triple net leases. Think about the situation of that. Maybe I got to change these leases to be triple net because now it's fine. Now I don't have to pass on the, very much to the tenant. The tenant won't have a problem. But especially if I have big commercial property, if there's a situation where my kids inherit, if I don't use a triple net lease, my kids, the trust, they eat the difference. They get stuck shouldering the burden of the property tax, and it's going to ruin the profit margin of the lease. If I have a triple net lease, that problem, usually after a year or so, becomes the tenant's problem. And that inheritance problem was not my kid's problem. It's the tenant's problem. Tenant's going to be mad, but it's business. So that's the potential risk there. But it's better to have a solution that you say, this isn't my problem, and then negotiate that, okay, fine, all right, tenant, I feel bad for that. We'll split the difference. Better would have been 100% my problem. Now it's only 50% my problem. Could have been 0, but I split the difference. It's now 50%. Better than 100. You did well. And so that's the thought there. Recognize the rental real estate may be sold if it's reassessed. That's often can happen. I've seen this in trust, very common amongst Chinese families, that they say the rental real estate portfolio shall never be sold. We shall never sell any of the real estate. When it gets reassessed, the wisdom of that may be very wrong. So you have to be quite cautious with provisions like that, that the real estate may never be sold because it may be, if we're only earning a couple $100 a month on it, that's not a good return. So that can be a problem, especially when we could sell it tax-free because we got the double step-up basis. So I could have sold it and all capital gains would be washed out. But if I'm holding it, I just have all of my capital locked up in a fixed asset with very, very low rate of return. Not good. If you have an estate over $10 million, we really got to start talking about annual gifting. You really got to start talking financial professionals, your 9 Fortunes team people, things like life insurance, annuities, all these different things. We got to start thinking about this because you're hitting that estate tax limit, and that has a snowball effect. When you get to 10, to get to 11 and get to 12 gets easier and easier. It's ironic how that happens, but it does. Gets faster and faster and faster. And ironically, which is really strange because it's counterintuitive, we got to slow that down. Why? Because as it grows and grows and grows, it's going to get hit by a 40% haircut. So we need to grow in a way that we slip under the haircut. Because if we grow and grow and grow, we say, oh, Mike, I got it up to 20 million. I say, okay, well, 20 million, let's say, 10 million over, 40% of 10 million, $4 million. So actually you only are 16 over. Like, oh, that wasn't a very good return. No, it wasn't. You had a problem there. We probably could have done it in a more efficient way where you would have ended up with the actual 10. So there's that. As I mentioned, irrevocable life insurance trusts, fantastic tool, reduce the size of the estate and reduce risk. This is us. I'll actually, gosh, just bang on 750. leave some time for questions if we have any questions. This is us. Please feel free to use our QR code, our website. Great way to contact us is info@ruiattorneys.com. Telephone, is great too. Telephone, just because we get frequent calls and sometimes it's missed or it's busy. Feel free to use the email. Works really great. That number also takes text messages. You can use that for text messages as well. So that works well too.
Hey, thank you, Michael. This is really packed with information, and
we went fast. We kind of went fast,
but I mean, it's very useful too, because like there's a lot of horror story I heard around the area. If they didn't plan it well, there's a lot of heartbreaking. Right now we're open for question Q&A, and you could choose whether you can raise the hand, we can unmute you so can you ask directly, or you can type in the chat box of your questions to Michael.
Yes, feel free to use the chat box. That works great if you like the chat box. All of those are good. If you happen to have any questions, I'm happy to answer.
Any questions?
And also, like I mentioned before, feel free, if it's more something that you kind of want to reach out offline to talk about, that's perfectly fine too. The email's great.
Could you share, Michael, share the last screen, because they want to get your info, your QR code. Yeah, exactly. So that they can snapshot it and take a photo so that they know how to reach you. Right. Here's Sharon has a question. It is the first time to hear estate tax return. What is it and how to file?
Oh, yes. So the estate tax return is only filed in a person's lifetime once. So this is partly why I've never heard of this return. It only happens in our lives one time. It is the return that's filed when someone passes away. So during your lifetime, you won't be filing one of these unless you make big gifts. Then you're filing the gift tax return. That's the form 709. We're talking about the estate tax return form 706. So what is it? When someone passes away, there is, in some situations, an obligation to file an estate tax return. But in all situations, you have the ability to file the return anyway, just to claim that ticket. So it's the form 706. It is filed after someone passes away. The deadline is 9 months after the person passes away, but can be extended for another 5 months for a timely return. And then a late return can be filed often up to 5 years, but it has to be done in a particular way. Accountants often don't like this return because it's not commonly done by them. The other thing that they don't like about it is it's a little bit of an awkward return, and it's also manually filed. So like when we file them, can you believe they're actually filed by paper? And it's this big bundle of paper that is actually sent. One time we actually sent it, had to be, this was for a large estate, but it was actually sent by, you had to send it by courier because it was a huge banker's box to send the thing to the IRS to send it. So that's what it is. For estates that are on the larger side, it can be very, very helpful. So very nice question.
Yeah, sorry, I just drop off. Yeah. Oh, so that's a very interesting info, because so you recommend that actually not the regular tax preparer would do this. It's more along the line of estate planning attorney will be doing that.
And I think the thing is, it's always a level of comfort with them. Is that I've had a lot of CPAs, and some of them say, "Oh, I'm familiar with these." Especially CPAs that have been in practice for a long time. They say, "Oh, it's been a reality. I've been in practice a long time. Sometimes this happens to clients, and I prepare this return, and I know how to do it, and I'm familiar." And fantastic, great. And then I've had other CPAs, which happens actually fairly frequently. The person who's calling me is the CPA, as they said, someone came in for a 706. I don't do the 706. That's not something that I want to do. I've done their taxes for years, but this thing is not something I've ever filed before, because I don't normally do that as a CPA. I normally handle the 1040, I handle the 1120, and I handle the 1065, the big three. I don't handle that kind of weird one. So that's very common.
But that's actually a testimony that, for a long time, especially in Silicon Valley, a lot of tech people, right, IT people, kind of like do DIY, right? So we file taxes ourselves and TurboTax and stuff like that. One thing I learned that more and more you do it, you really will miss a lot. You don't know what you don't know. So I could change my mindset. So I hope everybody can kind of understand that. Find a professional to do what they do best. Be it the tax filing and be it trust planning and stuff there. So find a professional to do it. And let's see whether there's other questions out there. Oh, we find it's like, any questions?
Oh, great.
There's no more question, I think.
Yes, and if everybody has kind of good basics, I think that's excellent. And then, like I said, easy to find. Feel free to reach out to me. And of course, if you can't find me, the Nine Fortunes team, they can always figure out where I am. I'm never that far. So very, very simple.
Wow, there's a blanket question. There's a blanket question here. Let's see where you want to tackle that one. How much fee to trust?
And actually, I will tackle that one because we're very transparent about it. Generally, the fee for a average family, we're not, nothing crazy going on, is generally around $2,500 to maybe for a complicated one, maybe $3,500. The fee is not expensive, and that's the thing which is always kind of gets us out there doing seminars all the time, is because the fee to solve the problem is not high, but when the problem comes out, the fee is massively high. And that's the thing, like with the John Paul Getty thing, where the fee is $38 million. The reason is because the fee is set by law. So this is very interesting, like with probate. If you pass away and you have to go through probate, the attorney doesn't talk the fee with you. The attorney says, oh, let's do the probate. Let's do it. Just sign this thing. Bring me aboard. And you sort of say, oh, what about the money part? They say, we'll handle that at the end. The court will tell you what to pay. Don't worry about that. We'll handle that at the end. The court will tell you what to pay, because the law tells you what to pay. And if you get to the end and you say, I don't like that fee, the court says, too bad. The law says that's the fee. Very famous in the John Paul Getty case, the family protested the fee, and it went up to the higher, among the highest levels of the California courts. And they said, there's no complaining. The law is the law. You calculate it, and which is really bad. Which happened in the John Paul Getty case when they fought it, is that the attorney said, not only do you owe the fee because you fought me for the fee and I had to defend the fee, you owe me the fee to defend the fee. So you owe me even more. So that's not so great. So we don't want to do that. Fee to cover like revisions and things, it really depends on the kind of revision. Some revisions are very routine, like change of trustees. That's a nominal fee to basically just cover the little bit amount of time to do it. Sometimes, like if there are major changes that we have to amend and restate the trust, that would be an additional fee. But really, this is the other thing, like looking at timeframes for like how often do you need to revise the trust. The key thing is really actually thinking not raw time. The key is thinking life changes. So where I am in my life, married with young children, I'll probably need my trust now probably is pretty solid for maybe about 15 years. My kids won't be grown up for a while. So I have a good long time. I'll get a good long life out of that trust before I need to do another major revision, providing the tax law doesn't change. But right now, we'll have a split Congress. Odds of the tax law changing, don't quote me on this, but my gut, not a lot of changes for a good long time. Hard to change this law. It's kind of the way that it is. So we won't have tax law changes. So a good time if your family is in not in a period of time of a lot of people changing around, a great time to plan. Asset updates or transfer of assets to the trust. That's a good question. So asset updates, the great thing with the trust is like with the way that we draft them with the schedules on the back, the schedules are very easy to self-adjust because you basically have a template, you can self-adjust, and it does not need a notary. So you can essentially just do them. I have clients that just do them, or we do it up for them, and they just mail them back to the office, or they add it into the binder. Transfer assets to the trust to do a deed, it depends the situation. Generally, the cost for a deed is a couple $100 to do the deed. But if you're buying a new house, usually you don't have to pay at all. Just tell the title company you want to put your the new property into the trust, and do give them the certificate of trust. They'll do it for you, and they'll make sure everything's in there. So acquiring new property usually pretty simple. So that's
great. Thank you very much. And the times is right on the dot. And
yes.
Thank you very much, Michael. And it's great information. And please contact Michael for a further inquiry, and how Michael will definitely be able to help you to set up the strategy to have a harmonious estate planning.
Oh, great. And thank you so much for hosting. It's always a pleasure to be with everybody. And I wish you all the very best of holidays. So take care and be well.
Thank you very much, and good evening. Goodbye.
Goodbye.